before us is Gomez versus Summa Health System, and I see both sides here, and you're ready to proceed?
Yes, Your Honor.
You each will have 15 minutes, and you can reserve up to 5 minutes for rebuttal. We'd like to remind people that you should keep your voice up, identify yourself to the court, who you're representing, and also that we are recording all this for our YouTube channel, so it will be available for posterity. And so as a result, we also remind people too, if it's relevant, that you not to use the name of victims or minors in any shape, manner, or form. Just refer to them as a child or as the victim. All right, you ready to proceed then?
Yes, Your Honor.
Okay. You may begin.
Come to the podium.
Yes, please. I'm sorry. Yes, and please stand behind the podium because that's where we'll be recording.
Thank you. I want to thank the court in advance for this opportunity, and I'd like to reserve 5 minutes for rebuttal, Your Honor.
Sounds good. Thank you.
This is a wrongful death action that was dismissed on statute of limitation grounds, Your Honor. But me, Mr. Hurley, is my name, and I represent the Gomez family. We'd like to bring to the court that the wrongful death statute states that competent medical authority or a reasonable due diligence will begin the clock for statute of limitations, Your Honor. And just to give some of the facts, Your Honor, in this case, I didn't receive the medical records. I got involved in this action late in the process, Your Honor, because I guess Mr. Gomez unfortunately passed away December 14th, 2020. I met his family members in September of 2022, really earlier than that, like August of 2022. They wanted me to look into it, and I did, and I made a request for the medical records from the appellee, Your Honor, and received them September 22nd. It was voluminous of over 1,200 pages, Your Honor. After doing my own research and investigation and due diligence, I presented our motives and where we wanted to go, the family, to the appellee, Your Honor. And I initiated contact with them on October 17th, 2022. I was told to present a demand letter to them in November, which I did, of 2022, and didn't get a response back until November 22nd, 2022, Your Honor. But I would like to state that the statute states that, again, after competent medical authority states that this was a cause or due to reasonable due diligence on the family's part, then the clock starts at that time. So we would state that the clock started after I got the medical records and did my own investigation and came up with a theory to move forward with, Your Honor. The statute also states that if it's dealing with a product liability case, there's a 10-year period that can start the clock also, considering the fact that it's dealing with a product that's listed in the statute. We'd also state that 2305.10 is applicable to this case, and that also states competent medical authority or reasonable due diligence also, Your Honor. What it is, the state of Ohio is articulating that at the point of death, the clock doesn't automatically start, because it's a traumatic event. You don't know exactly what's going on. It's going to take reasonable due diligence or competent medical authority to determine if there was a wrongful action in dealing with this unfortunate event, Your Honor. We'd also like to say that the discovery rule is applicable to this case also. And the court stated the following in regards to the discovery rule in McDowell v. DiCarlo. Although the Ohio legislature has provided the application of the discovery rule, i.e. the discovery of a cognizable event which does or should put a plaintiff on notice that a tort has occurred in regard to product liability and exposure to certain toxic substance claims, Your Honor. So basically, to make a long story short, Your Honor, we didn't discover it. I didn't discover it until late in the process. We feel that the clock should start once I did find out what was going on, Your Honor. And we feel that this case should be returned back to the trial court to be decided on this marriage, Your Honor.
If it's not a product liability case, I understand you filed a wrongful death, but if the underlying death was allegedly caused by medical malpractice, explain to me your theory again on that. Is that when the discovery rule would come into play again?
Well, we did, the trial court determined rightly that it wasn't, we weren't trying to allege a medical malpractice case, Your Honor. We were alleging that there was a misuse of a product that caused this demise of Mr. Gomez, Your Honor.
Right, but wasn't the misuse of the product based on a doctor's instructions as to how to use it?
Yes, Your Honor. And that's correct, Your Honor. But even in that instance, it still be subject to a competent medical authority or a reasonable due diligence clause to, Your Honor.
You may proceed.
Oh, yes, Your Honor. Basically, that's basically it, Your Honor. We would like to bring to the court's attention, Your Honor, that, again, as I stated, the process started for the family. They came to me late September 2022. I made an immediate request for the records from the appellee, Your Honor. They're voluminous. It was over 1,200 pages. I reviewed all of them. Within 30 days, I contacted the appellee. I was told by the appellee to present, a demand letter to get the process started. I did that, Your Honor. They dismissed any, allegations that they were at fault here. That I immediately filed the case from that point on, Your Honor. And I would just like to state that, again, that the statute states that if a product liability is a 10-year clock, and there's also, again, the competent medical authority clock or reasonable due diligence, Your Honor.
Thank you.
Thank you.
Good morning.
Good morning.
May it please the court, I'm Rocco Potenza, and I have the privilege of representing Summa Health System and all the other Summa entities that I'm not going to list in this case. I just wanted to talk about a couple of things first of all. This case involves Victor Prito, who came to Summa because he had a medical problem. He came because he was experiencing symptoms of shortness of breath and other respiratory problems. He came for a diagnosis and treatment. He was a patient for a number of months, a number of weeks, required intubation, and unfortunately he passed away. There is no dispute that the plaintiffs filed this complaint more than 2 years after Mr. Prito's death. In the complaint, there are specific allegations that the providers involved in his care and treatment inappropriately diagnosed and treated Mr. Prito, and that is the basis for this claim. The trial court, applying the wrongful death statute of limitations, concluded that the case was barred by that statute. The wrongful death statute provides, in pertinent part at 21-2502 F1, a civil action for wrongful death shall be commenced within 2 years after the decedent's death. That did not happen here. Several arguments have been raised as to why that should not apply in this case. The first one is an assertion that this is a products liability case. The portion of the statute that plaintiff cites is in regards to exposure to a dangerous toxic substance. That's not the situation here. Mr. Preto was treated with various modalities of treatment, including medication. It's not a products liability case. The products liability statute specifically, so you can either be a manufacturer or a supplier. Clearly, Summa and the physicians are not manufacturers. And the question then becomes, are they a supplier? The statute, 2307-71 defines who is a supplier and who isn't a supplier. And specifically at subsection A15B, it states, a supplier does not include a provider of professional services who, incidental to a professional transaction, the essence of which is the furnishing of judgment, skill, or services, sells or uses a product. So this case is about medical providers who made a decision to treat using their training, education, and experience with certain medication. The appellant objects to the use of that medication and claims that it's inappropriate, but it was a result of the exercise of these individuals' judgment.
Does the plaintiff allege product liability in the complaint at any point?
There is no allegation of product liability in the complaint. The specific statements are negligently treated him with the medication and inappropriately diagnosed and treated the patient. You know, I pointed out in the briefs, I'm not going to belabor them, but the one statement, and this goes to how a court determines the nature of the cause of action. You have to look to what the substance of the action is. And the Supreme Court in Hunter v. Shenango indicated the crucial consideration in determining the applicable statute of limitations in a given action is the actual nature or subject matter of the cause rather than the form in which the complaint is styled. So courts throughout Ohio have held, in malpractice cases, clever pleading can't change the nature of the claim. As you pointed out, Your Honor, there is no claim in the complaint, but the argument is a clever argument to avoid the application of the appropriate statute of limitations. The next argument from plaintiffs is that the discovery rule somehow alters the wrongful death statute and the triggering of the statute of limitations. Again, I think we need to be mindful that the statute does say specifically 2 years to commence a civil action for wrongful death. A number of courts, and I cited those cases in the brief, one from this court, Corp, a malpractice case, talked about how the discovery rule would apply to wrongful death cases. And they go through the analysis of Akers, Hirschberger, Elenius, I can't pronounce that, where they talk about the occurrence of a cognizable event, something that triggers the concern that you need to pursue your remedies. You don't have to have knowledge of all the things you need to pursue a malpractice case. And in these cases, in that case in particular, the court said, thus, once a patient becomes aware of an injury, it is incumbent upon that individual to investigate his or her case completely. My research has failed to disclose any case, any malpractice case in Ohio where anything other than death contemporaneous with the care and treatment as triggering the statute of limitations. I just don't think there's a case out there that said it's some other time. And how would we judge that other time other than death? It's probably the single most significant event that would cause one to think it may be related to a medical error. In the estate of Glenn case, court stated, in the instant case, appellants had the most obvious reason of all to suspect malpractice, i.e. the death of the decedent patient immediately following a medical procedure. Again, I think there's no question that the trial court appropriately concluded that the statute began to run upon the decedent's death and that the claim was filed more than 2 years after the date of death.
Counsel, in your brief, you talk about, in regard to cognizable event discovery and so forth, in regard to medical malpractice, and you cite a case from the 4th District that talks about discovering that it should be the cognizable event was the date of the defendant's death, not that the date appellant discovered the potential culpability of Dr. Leon. Okay, so my point with this is, isn't there a difference between maybe not knowing who was responsible for the death as opposed to being on notice within a certain time frame or immediately on the death, just that the person died of malpractice?
Sure.
Most times you don't know if somebody dies, it's malpractice.
Okay. And you would think there'd be a case out there where a court applied, or an appellate court applied a different date other than death. I don't think there is one out there. And I would point the court back to the Ohio Supreme Court decision in Flower v. Walker. In that case, the court stated the occurrence of the cognizable event imposes upon the plaintiff the duty. So there's two things. So in the Leon case, it was the second aspect of Flowers. But the first one was the occurrence of the cognizable event imposes upon the plaintiff the duty to determine whether the injury suffered is the proximate result of malpractice. So it's not, you have to conclude that it was malpractice. You need to, it triggers your duty to investigate. And then the second prong is not only do you have to investigate whether or not it was the product of malpractice, but who it was that committed the malpractice. That's the other part. So again, I think the courts out there that have addressed this issue have all concluded, unless I missed something, and I don't think I did, I'm not perfect, but I have not found a case where they applied any different date other than the death.
What about the situation where, because all these things run through my mind, so
Sure.
I'll just ask you, what about the situation where somebody dies and the hospital says, you know, it's a heart attack, and then an autopsy 3 months down the road, 4 months, 6 months, whatever, down the road determines that actually it wasn't a heart attack, the wrong, the wrong medicine was put in an IV that poisoned the person.
Mm-hmm.
So it's not you would have no idea at that point to say that's the cognizable event was the death, because at that point you were told it was a heart attack.
Again, I think the case law that I've cited addresses those sorts of questions and said it's the death that triggers the plaintiff's duty to investigate whether or not it was malpractice, not simply upon somebody else notifying. It's kind of like the situation, there's a number of cases that talk about whether, where the plaintiffs argue that it wasn't until our expert told us it was malpractice, right? I think that's analogous to the situation you have.
Except that
cited.
in my situation, there's not a cause of death.
Right, so you don't know.
Until the coroner, or until the autopsy is done.
Yeah, I mean, I understand your point, I respectfully
Yeah.
disagree, and I think in all the years, I think let's see, these cases go back to the early 90s that talk about the statute of limitation, the discovery rule, and the cognizable event, and you would think there would be one case where that type of circumstance would have permitted. The other thing I wanted to state is, let's say hypothetically you chose to say, all right, there's some other date for the cognizable event. First of all, when is it? Do you have until you go to an attorney 2 years later that it starts the running? I don't think that possibly can be the case. The other aspect, in this case, I also cite the Clausen and Worth decisions. Those cases stand for those are Ohio Supreme Court cases where they hold a hospital or a medical employer is not capable of being directly liable for injury. They're only vicariously liable for the conduct of individuals they can be responsible for, either an employer or an agent under agency by estoppel. If those claims against the individuals are extinguished by the statute of limitations or for any other reason, those cases indicate that the claim against the hospital is likewise extinguished as a matter of law. I appreciate your time. Thank you. Unless there's any other questions, I'm sorry.
That's fine. I don't believe so. Thank you.
Thank you.
You will still have your 5 minutes.
Yes, Your Honor. Again, thank you, Your Honor. I just wanted to state that the statute substance doesn't automatically deal with a dangerous product. It says any product or service. In statute chapter F1, in regards to a substance that's provided that triggers a 10-year limitation, and a supplier could also be an issue that could be a question of fact if presented to a jury, Your Honor. And in conclusion, Your Honor, we just ask that the case be returned to the trial court, Your Honor, to be decided on its merits, Your Honor. Thank you.
Did the trial court make a determination that Summa Health System was not a supplier or was a supplier?
No, Your Honor. The trial court made a determination that this was not a medical malpractice case. It was a wrongful death case based upon based upon my allegations of a misallocation of a product, Your Honor. They did not decide on the merits of any other issue, Your Honor, like that, Your Honor.
Well, thank you very much for
Thank
your presentation. Thank you both.
Thank you, Your Honor.
The court will take the matter under advisement, and we will issue a written opinion, which will in turn be sent to both sides, and you can also look on the Supreme Court website for the electronic release.
Thank you, Your Honor.